Meyiwa was a well-known professional footballer who played for Orlando Pirates as a goalkeeper in the Premier Soccer League and for the South African national team Bafana Bafana. The deceased was shot and killed in the house of his ex-girlfriend, Miss Kelly Kumalo, on the 26th of October 2014 while paying her a visit. On the 16th of June 2020, the investigating team led by Brigadier Geninda, who is the head of the National Court Cases, arrested Bongani Ntanzi, accused number 2, in respect of this case. On the 19th of June 2020, accused number 2 made a confession statement before a commissioned officer, Colonel Rapado. On the 24th of June 2020, accused 2 made a second confession statement before a magistrate, Ms. Cronje. It was on this basis that a confession statement which led to the arrest of accused number 4 before court. On the 17th of July 2023, the trial commenced de novo, and it has been on a running roll for a period of over 2 years. It has been televised nationally, international, and on print. It has also been marked by delays during this period. Accused number 4 has been in attendance throughout the trial. It is no doubt that at some instances, valuable court time has been wasted. The rationale for Section 174. The rationale for the rule in terms of Section 174 was described as in State v. Morero, unreported GP case number A523 of 2015, dated 22 January 2016 at paragraph 54. And I quote, "It caters for the prescript of the Constitution for the fair criminal trial, namely the presumption of innocence on the part of an accused until proven guilty and his or her right to silence. It further puts an abrupt end to a case which has no prospect of being successful in circumstances where the evidence falls abysmally short in proving even a prima facie case against an accused, thus ensuring that valuable court time is not wasted and unnecessary expense is not incurred." Section 174 thus gives the court to decide not to put the accused on his or her defense if there is no case to answer. There is no formula for or test applicable to all circumstances when deciding whether or not to discharge. Each case must be decided on its own merits in order to reach a just decision. The charges. The accused, including accused number 4, are charged with the following offenses. The accused, including accused number 4, are charged with the following offenses: murder read with the provisions of Section 51, subsection 1 in bracket of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with sections 92 subsection 2 in bracket 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about the 26th of October 2014 and at or near Fostoras in the district of Boksburg, the accused did unlawfully and intentionally kill Mr. Senzo Robert Meyiwa, a 27-year-old male, by shooting him with a firearm. The provisions of Section 51 subsection 1 in bracket of Act 105 of 1997 are applicable in that the murder was planned or premeditated. B, the death of the victim was caused by the accused in committing or attempting to commit, or after having committed or attempted to commit, robbery with aggravating circumstances, as defined in Section 1 of the Criminal Procedure Act 51 of 1977. C, the offense was committed by a person, group of persons, or syndicate acting in the execution or furtherance of a common purpose or conspiracy. Count 2, attempted murder. In that upon or about 26 October 2014, and at or near Fostoras in the district of Boksburg, the accused did unlawfully intentionally attempted to kill Zandile Lorraine Kumalo, an adult female person, by shooting at her with a firearm. Count 3. Robbery with aggravating circumstances as defined in Section 1 of Act 51 of 1977, read with the provisions of Section 51, subsection 2 of the Criminal Law Amendment Act 105 of 1997, as amended, and further read with Sections 92, subsection 2, 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about 26 October 2014, and at or near Phosphorus in the district of Bosbeck, the accused did unlawful intentional assault Miss Kelly Kumalo and or Gladys Kumalo, and did with force and violence take a Samsung S4 cell phone, the property or in lawful possession of Miss Kelly Kumalo and or Gladys Kumalo, and did rob her of same. Aggravating circumstances being present in that the accused made use of a firearm. The provisions of Section 51, subsection 2 of Act 105 of 1997 are applicable in that there is presence of aggravating circumstances. Count 4, contravention of Section 3 of the Firearms Control Act 60 of 2000, possession of firearm. In that upon or about 26 October 2014, and at or near Phosphorus in the district of Bosbeck, the accused did unlawfully and intentionally have in their possession a firearm to with a 9mm CZ model 75 with obliterated serial number without being in possession of a license to possess the said firearm. In respect of this count, the state alleges that the accused jointly possess a firearm which is the subject matter in this count. Count 5, contravention of Section 90 of the Firearms Control Act 60 of 2000, possession of ammunition. In that upon or about the 26th of October 2014, and at or near Phosphorus in the district of Bosbeck, the accused did unlawfully intentionally have in their possession an unknown number or quantity of 9mm parabellum caliber ammunition without being in lawful possession of a firearm capable of firing such ammunition. The summary of substantial facts in terms of Section 144, subsection 3, in brackets, small letter A, in bracket of Act 51 of 1977, details, amongst others, that there were several other persons in the house, namely Miss Gladys Kumalo, the owner of the house, who is the mother to Kelly, Miss Zandile Lorraine Kumalo, sister to Kelly, Mr. Longwe Twala, boyfriend to Miss Zandile Kumalo, Mr. Tumelo Madlala, friend to Mr. Senzo Meiwa, and Mr. Mthokozisi Twala, a friend of Mr. Senzo Meiwa, in the lounge or dining room. A cell phone belonging to Miss Kelly Kumalo was taken, and the assailant fled, dropping her head on the premises. It is important, my Lord, to mention that in respect of count 3 of the indictment, Ms. Kelly Kumalo was not called to testify despite being the complainant in that count.
Despite what?
Despite being the complainant in that count, in count number 3 of the indictment.
I thought there were 2 complainants. Mr. Valoy, is that not so?
Yes, indeed. The other complainant is the mother.
The mother, yeah.
Yes,
Yeah.
both of...
Okay.
In fact, I should say, my Lord, that both of them were not called before this court to come and testify about the circumstances of the robbery, which occurred on the 26th of October 2014 in the house in their presence. The state will allege that the accused were acting in the furtherance of a common purpose to commit the crimes as per the indictment. The duties of a prosecutor. In terms of Section 25 of the National Prosecuting Authority Act 32 of 1998, determines the powers, duties, and functions of prosecutors. Section 25, subsection 1, provides that a prosecutor shall exercise the powers, carry out the duties, and perform the functions conferred or imposed on or assigned to him or her, A, under Act 32 of 1998 and any other law of the Republic. B, by the head of the office or investigating directorate where he or she is employed or person designated by such head. Or C, if he or she is employed as a prosecutor in the lower court by the DPP in whose area of jurisdiction such court is situated or a person designated by such DPP. A prosecutor has a duty to pay attention to the contents of the police docket. In this regard, see Minister of Police and another versus Duplessis, 2014, Volume 1, SACR 217, SCA. The summary of substantial facts in terms of Section 944, subsection 3, in bracket, small letter a in bracket of the Act 51 of 1977, details that the deceased, Mr. Senzo Meyiwa, died during or after the commission of the robbery, which gone wrong. Brigadier Kininda, in his evidence, details a hit to kill the deceased and based this argument in the investigation done and or conducted by the investigating team on the following. The evidence of Colonel Lambertus Steyn. Colonel Steyn testified that he was employed by South African Police Service and in the service of the state, attached to the National Court Case Unit investigation based in Pretoria, National Head Office, where he acted as an analyst and an investigating officer. On the 9th of April 2020, at about 10 o'clock, he received a series of Section 205s and cell phone downloads from the investigating officer, Brigadier Kininda. He testified further that Brigadier Kininda requested him to determine if there are any linkages between the current suspects and the people in the house at the time of the crime. The transcribed record of the 27th of July 2023 at page 64, line 10 to 15, states the following. Mr. Steyn, I just want to draw attention to the court that as well that a Section 205 information, not one of the team members applied for that, but it was stored on the central database of the police. So that is why it was being applied for by the previous investigation officers. But we did have access to that. Then my next point, during my analysis, I discovered that Kelly Khumalo with number 278270444358, she received a call from Ndu Linkani with number 27733059203. This appears from the transcribed record of the 27th of July 2023 at page 75, line 6 to 9. According to Colonel Steyn, communication between the two numbers occurred on two separate occasions. That is on the 2nd of August 2014 and 15 October 2014. The details of the communication are reflected on page 23 of Colonel Steyn's affidavit, Exhibit 01. It is important, my lord, to mention that the information from the central database of the South African Police Services was editable, and the state did not call any witness to authenticate it during the course of this trial. The state, by this communication, that is communication between the two numbers, intended to prove communication between the mastermind, which according to the brigadier, that is Brigadier Kininda, was Ms. Kelly Khumalo and accused number 5. Accused number 5 then procured the services of his co-accused, that is accused 1 to 4, in the execution of the murder. The evidence of Ms. Pinky Vitilingam. In fact, the Section 205 records from Vodacom depicts a different scenario with regards to the communication that Colonel Steyn testified about. It details that, in fact, Ms. Kelly Khumalo with the number 278270444358 had received calls from Mr. Arthur Mofokate and the deceased on the 2nd of August 2014 and 15 October 2014, respectively. The evidence of Ms. Pinky Vitilingam. I submit, my lord, that there were discrepancies between the analysis of Section 205 records analyzed by Colonel Stein from the central database of the South African Police Service and the extracts of the Section 205 records, that is Exhibit J1. Ms. Pinky Vitilingam could not give an account of such discrepancies. She could only state that she could only testify about the Section 205 records from Vodacom, which depicted, as I've said earlier, my lord, the communication on the 2nd of August 2014 and 15 October 2014 between Mr. Arthur Mufukate and the deceased Mr. Senzo Meiwa to Ms. Kelly Kumalo. The data cell phone records do not disclose such communication between Ms. Kelly Kumalo and accused number 5 before this court. The SMSs between Ms. Kelly Kumalo and her sister Zandile Kumalo that reveal the following. In this regard, see page 6 to 12 of Exhibit 01. The trial commenced through the witnesses' evidence who were inside the house when the incident occurred, painting a picture of the robbery gone wrong. But when the trial progressed, it built around the assassination of the deceased. Brigadier Kininda described Ms. Kelly Kumalo as the mastermind and the trigger point in the execution of the deceased murder. And to that extent, he, Brigadier Kininda, applied for a warrant of arrest against Ms. Kelly Kumalo, which was never executed. As he says, it was a prosecutorial-driven investigation. I'm well aware, my lord, that the state is not bound by the summary of substantial facts, which means that the evidence not disclosed therein or which differs from it will not be inadmissible on that ground alone. In this regard, see State versus Van Vuren at page 21, paragraph D to F. The court will nevertheless, in the evaluation of the state case, compare the evidence given with what the state indicated its case will be. See State versus Holoko 1991, volume 2, SACR 203, capital letter A in bracket, at page 207, paragraph B to C. It follows that it is therefore crucial for the state case to indicate that the accused entered into an alleged conspiracy agreement with Ms. Kelly Kumalo. Failing such proof, the accused, that is accused number 4, cannot be convicted on any of the first 3 counts against him, and accordingly not on the 4th or 5th count. The legal position. I've referred to the provision of Section 174 of the Act. The plural is that he ought to be acquitted. That is the accused, if it is reasonably possible, true that he might be innocent. My own emphasis. The word no evidence in Section 174 of the Act means no evidence upon which a reasonable person might convict the accused, as stated by Ramsey J. Instead versus Kanyapa, 1979, volume 1, SA 824, capital letter A in brackets, at page 834, paragraph F. It is well established that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. The question whether a court should grant a discharge at this stage is one which entails a discretion by the trial court. It is a discretion which must self-evidently be exercised judicially.
Ngaphansi kwezomthetho-ke lapho-ke la ekhuluma phecelezi nodaba luka-section 174 lapho isicelo sathi aqhamuke ngaso-ke lapho-ke lathi khona ekugcineni kwecala lezombuso-ke lapho-ke kwamele ukuthi khona-ke njalo lapho-ke uma ngabe-ke abantu bebona ukuthi kanjalo abanalo icala phecelezi nabo kwamele balethe isicelo lesi-ke lapho-ke athi futhi kwamele ukuthi inkantolo uma ibabona bengenalo icala kwamele ukuthi badedele-ke ngoshweleke lapho noma ibadedele nje kuphela-ke lapho-ke wathi washo khona njalo lapho-ke nanoma kusho lokhu-ke athi ngaphansi kwezomthetho zomthetho zika-section 174 lokhu akusho ukuthi ubufakazi lapho-ke abukho-ke lapho-ke ubufakazi obukhethekile ubufakazi obubambekayo lapho-ke obungaze buphoqelele thizeni-ke abasuke bagcine lapho-ke bethuswa-ke icala-ke lapho-ke futhi buyaqhathanisa phakathi icala lapho lika-Ramf CJ futhi licala libhekene necala lozombuso-ke lapho-ke noma icala lika-Khanyapa laka-1979 SACR SA 824 lapho-ke A futhi washo khona njalo lapho-ke kwamele lokhu kubhekwe futhi kubhekisiswe kahle-ke lapho-ke uma ngabe ufakazi lobu kade ufakazi obukhethekile mhlawumbe ufakazi obubambekayo noma ufakazi obubambekayo obunesihlahla noma ufakazi obunobisindo lapho bungekho khona-ke kwamele ukuthi lapho inkosi yenkantolo mhlawumbe inkantolo lokho isebenze ngendlela ekhethekile futhi ngendlela ejulile lapho thizeni-ke idedeleka abantu-ke lapho-ke kumacala ade bathusa wona-ke.
Judicial pronouncement on the manner in which the trial court must exercise its discretion has been contentious. I do not intend to give a full historical overview. I will confine myself to a brief reference to those cases that helped to define the scope of the court's discretion in terms of Section 174. In State versus Shuping and others, 1983, Volume 2, SA 119, capital letter B in bracket. The IMSTRA CJ reviewed the case law history and of discharge application and formulated the test as follows at 120 to 121, capital letter A. And I quote, at the close of the state case when a discharge is considered, the first question is Roman figure 1. Is there evidence on which a reasonable person might convict? If not, Roman figure 2. Is there a reasonable possibility that the defense evidence might supplement the state case? If the answer to either question is yes, there should be no discharge and the accused should be placed on his defense. Close quotation. There is criticism in respect of the second test in the Shuping case. And the criticism labeled was referred to in State versus Lubata 2001, Volume 2, SACR 702 SCA inter alia, as follows. At paragraph 14, the criticism of Shuping's case relates to the second leg of the inquiry, which permits an accused person to be placed on his defense, even when there is no case to answer, merely in the expectation that the defense evidence might supplement the prosecution's case. To place the accused on his defense in those circumstances has usually been said to be in conflict with the presumption of innocence. Close quotation.
Lapho kaqhathanisa phakathi kwelinye-ke icala selahlalela ngaphansi kwenkosi enkantolo-ke lapho-ke le cala kade akhuluma-ke ngalo-ke lapho-ke Shuping futhi nabanye-ke lapho-ke kahle lapho-ke no-M3 ijaji yakhona-ke lapho-ke nkulomnkosi enkantolo-ke lapho-ke lathi khona ekugcineni kwecala noma qhathanisa phakathi kwesicelo sakhe lesi futhi nesicelo secala leli ade akhuluma-ke ngalo-ke cala.
In State versus Lubata 2001, Volume 2, SACR 703 SCA, the following was said. The right to be discharged at that stage of the trial does not necessarily arise, in my view, from consideration relating to the burden of proof or its concomitant, the presumption of innocence, or the right to silence, or the right not to testify, but argued from the consideration that more general application. Clearly, a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation that at some stage he might incriminate himself. That is recognized by the common law principles, that there should be a reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated. See Beckenstrater versus Rota and Tiernesen, 1955, Volume 1, SA 129, capital letter A in bracket, at page 135, paragraph C to E. And the constitutional protection afforded to dignity and personal freedom in terms of Section 10 and 12 of the Constitution seems to reinforce it. It ought to follow that if the prosecution is not to be commenced without that minimum of evidence, so too should it is when the evidence finally falls below that threshold. That is preeminently to be so where the prosecution has exhausted the evidence and the conviction is no longer possible except by self-incrimination. A fair trial, in my view, will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by Section 10 and Section 12 of the Constitution, close quotation. It has been held that the credibility of state witnesses at this stage of the proceedings only play a very limited role. In State v. Mpeta and others, 1983, Volume 4, SA 262, capital letter C at 265 D to G, Williamson J. held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. Close quotation. Therefore, to summarize the legal position regarding application in terms of Section 174 is as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. B. Credibility of witnesses' evidence is only an issue where it has been the effect that the evidence is so unreliable that it can be said that no evidence has been adduced. C. Where the evidence of the state witnesses indicating the accused is of such poor quality that it cannot be relied on, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for a discharge should be granted. D. An acquittal must be in the interest of justice. E. Circumstantial evidence in the state case may be relevant factor in deciding whether a case against the accused is so strong that it calls for a reply in the witness stand. It is against this legal background that I find it prudent to refer to the portions of the evidence of Zungu in the record of the proceedings and later proceed to analyze his evidence. Constable Sizwe Sikumbuzo Zungu testified that he was a constable employed by the South African Police Services with 12 years experience under the invisible policing station at Sebenza Police Station. He knows all the accused before court. He knew Mthokoziseni accused number 4. He remembers him from Phosphorus, but not back home. On the 26th of October 2014, he received a call from Gwabeni. Gwabeni wanted to know from him, that is Zungu, whether he was able to come to Phosphorus on that day. He responded that it was still early because it was around 7:15, and that on that day he was still going to work. Gwabeni called him again and informed him that there was another brother of ours, Makosonke from Rustenburg. He informed him that Makosonke was also going to be joining us. He knocked off and contacted Makosonke Zungu. He informed him that he was at Johannesburg at Carlton Center. That is where he will find him. He went there and found him. They arrived at a hostel between 2 to 3. He will not be able to remember the exact time. It is against this background that I will proceed and analyze Zungu's evidence. According to the version of the state, the only witness who met and placed the accused at Phosphorus Hostel on the 26th of October 2014 was Constable Zungu. Constable Sizwe Sikumbuzo Zungu, who was a single witness. It is straight law that a court should approach the evidence of a single witness with caution. The following passage from the judgment of the Phyllis J.P. in R. vs. Mokoena, 1932 OPD 79 at page 80 is frequently cited. I quote, "The uncorroborated evidence of a single competent and credible witness is no doubt declared to be sufficient for a conviction. But Section 284 of Act 31 of 1917 that is the predecessor to the Act 51 of 1977. But in my opinion, that section should only be relied on where the evidence of a single witness is clear and satisfactory in all material respects. Close quotation. Instead, versus Weber, 1971, Volume 3, SA 754, capital letter A in bracket, the appellate division stressed that there was no magic formula which determines when the evidence of a single witness testimony may warrant a conviction in every case. What may be said, however, is that the evidence of a single witness has to be approached with caution. His or her merits as a witness must be weighed against factors which militate against his or her credibility. Thus, the mere fact that he or she has an interest or bias against the accused will not of itself obviate a conviction. It is necessary to assess the intensity of the bias in the light of the totality of the evidence. Close quotation. Corroboration. In State vs. Gently 2005, Volume 1, in bracket SACR 420-430, Clute JA in dealing with the approach to be followed by a court when it is faced with a situation where a court should caution itself in analyzing the evidence, said the following, I quote, "It must be emphasized immediately that by corroboration is meant other evidence which support the evidence of the complainant and which renders the evidence of the accused less probable on the issue in dispute." Close quotation. It is clear from the authorities that if corroboration was required, if it had, for purposes of the so-called cautionary rule, to be corroboration implicating the accused and not merely corroboration in a material respect or respects. The evidence of Zungu was not corroborated in all material respects. Skhumbuzo Zungu was not called by the state to corroborate the version of Zungu, insofar as traveling with Zungu to the hostel after he had received a call from Gwabeni to pick up Skhumbuzo Zungu at Carlton Center in Johannesburg. Zungu is the only witness who met the accused at Fostora's hostel. He was introduced to the accused by Gwabeni. It is surprising that this introduction was done to this witness when Zungu and the accused knew each other. Zungu testified that he was requested by a certain gentleman, that is accused number 5, was requesting him to remove his vehicle because he had parked behind the vehicle that accused number 5 was traveling. Zungu and others he was seated with went to buy liquor and they drove using an Uno motor vehicle. He was traveling with accused 2, accused 3, and the driver. There were 5 in total. From the body of Zungu's evidence, this is the only time that he had traveled with accused 2 and accused number 3. I also at some point went out to the shops to buy some alcohol and drinks with a certain lady and came back to Gwabeni's house. Close quotation. It is clear that Zungu does not place the accused, that is accused number 4, traveling together using the VW Polo hatchback grey in color that he alleged accused number 5 was using, leaving the hostel, and part of his evidence is that he saw accused 1, 2, and 3 coming in, following each other, going towards Gwabeni's room, and he followed them. Inside the room, accused 1 was in possession of a .38 special revolver, and accused number 3 was in possession of a 9mm pistol. Accused 5 came inside the room. He was followed by accused number 4. Zungu states the following at page 2, paragraph 5, line 1 to 3 of his affidavit, and I quote, "Around 9 p.m. on the very same day, I noticed Moses Spear Mafiga, open bracket, Sandy Sontanzi, close bracket, and Kani, open brackets, Fisokuhle Zungu Ntuli, close bracket, walking after each other to Gwabeni's bedroom from outside. He does not mention accused number 4, following accused number 5 to Gwabeni's room. At page 2 of his affidavit, paragraph 5, line 6 to 9, he states the following, and I quote, "I saw Moses giving Gwabeni a .88 special firearm and Kani giving Gwabeni a 9mm firearm," close quotation. At page 2 of his affidavit, paragraph 5, line 20 to 21, he states the following, and I quote, "Mthokoziseni Mapisa and Carlos Ngube walked into the bedroom and sat on the bed," close quotation. There are material contradictions between Zungu's evidence in chief and his written statement. The correct approach to any contradiction between the prior statement and the witness's testimony was, in respect, most useful, summarized by Oliphant J.A. Instead versus Mafada Diso in another, 2003, Volume 1, SACR 583 SCA. The head notes in that case is submitted accurately, reflected, was said and was cited by Nechben J. Instead versus Governor and another, 2006, Volume 1, SACR 322, capital letter E in bracket. In respect of the factual evidence of Zungu's evidence, the contradictions are material and affect his credibility. During cross-examination by Mr. Ramsepel in respect of Zungu knowing accused 2, this is how Zungu responded, and I quote, Mr. Ramsepel. "Now, accused number 2, because I will chop and change with respect to accused 1 and 2, but accused 2 himself says he does not know you in total. He just see you here yesterday in court, Mr. Zungu. If that was said or was coming from accused 3, 4, and 5, I would have agreed with you. Okay, where I was born or back home, where I was born, or he is Ndanzi. It is clear from Mr. Zungu's evidence, when question is posed to him by Mr. Ramsepele in respect of him knowing accused number 2, his response was that if that was said by accused 3, 4, and 5, that they do not know him in total, he was going to agree. The response by Zungu is a clear indication that he did not know accused 4, in the light of the fact that he says he was going to admit that he did not know accused 4 if such assertion was put to him by accused number 4. During cross-examination, Zungu testified that a typed version of his statement was made out of notes that he had written himself. And where there are contradictions in paragraph 5, he actually meant accused 4 and 5 entered Gwabeni's room and not accused 3. During cross-examination by Mr. Ramsepele about Zungu mentioning in his written statement that he went to Top Spa to buy liquor in the company of a lady, this is how Zungu responded. Mr. Zungu, I think maybe it is a manner in which it is put here, but I did go to Tops with the gentleman. We came back and then there is a lady that just want to go nearby, who had requested me to buy her a drink, and I did go out with that lady. In his evidence in chief, Zungu testified that the person wearing a cap was accused number 2 when he was confronted that in fact the person wearing a cap was accused number 4. He could not proffer any explanation. Zungu testified that at some point he met Brigadier Lishabane, who informed him that he was going to conduct his own investigations, and thereafter he would come back and inform him, but did not tell General Lishabane that he was at the hostel. The reason was that he did not want to give General Lishabane this information, that it was coming from him, and that he did not have certainty with regard to that. Clearly, Zungu had an axe to grind for the accused when one considers the compactness of his evidence. Zungu testified further that on the 13th of November 2013, he had a meeting with Brigadier Gininda. Brigadier Gininda asked him what he knew about the killing of Senzo Meyiwa. He told Brigadier that he knew nothing and there was nothing that he can talk about. Brigadier Gininda told him that he was going to do his own investigations. At that meeting, Brigadier Gininda was with Brigadier Tony. Zungu testified that the relatives had to shoot him. He spoke to accused number 1 over the phone and asked accused number 1 why his relative wanted to shoot him, because he, Zungu, also did not know anything about this matter and did not know anything. It is clear, my lord, that from the responses or the evidence of Zungu, he mentions that not even on one occasion that he did not know anything about this case. He said this in the presence of General Shabane. And on the 13th of November, when he had a meeting with Brigadier Kininda, he repeated the very same assertions that he did not know anything or knew nothing about the killing of the deceased. Thirdly, he mentioned this when he spoke, as you say, to accused number 1, when he was making inquiries about why his relative wanted to kill him, because he did not know anything about this case. Further, to proceed, Zungu could not explain what was the occasion on page, I'll come back to that, of Exhibit C, despite claiming that he was with accused 3 and 4 on the day of that occasion, the date of the 26th of October, 2014.
But you are saying Zungu's evidence is not corroborated in any of the evidence led in this court?
Yes,
Never.
never.
Remember, what's the time they say?
It's 11, facing a lot.
Yeah, hold. You remember there was evidence by Buthelezi, a gentleman called Buthelezi, who went to see accused number 1 to give him some washing items. Sorry, number 2, yeah, you're right. In Rustenburg, next to some supermarket there.
Yes, I remember that evidence, my lord, very well.
Yeah. And then there's another piece of evidence, I think I was accused number 1, who was drinking Irish whiskey and exclaimed that Senzo is no more, Senzo is no more. You don't remember that?
I remember that.
Okay, on that note, let's go and have a drink.
My lord, by corroboration, I meant corroboration which implicate the accused in the commission of the offense. And there was nothing, absolutely nothing in the evidence of Zungu that implicated the accused in the commission of the offense. In fact, what Zungu testified about, he referred to not less than 5 people that he met on that day. Not people he met on that day. He referred to not less than 5 people in his evidence. And such people were not called as witnesses in this case. And on the transcribed record of the 7th of September 2023, on page 29, line 10 to 14, this is what the court said about such tendency of this witness, Zungu, to refer to hearsay evidence. And I quote, by court, just to place it on record that I will not entertain the hearsay, I'm not going to take it into consideration. Mr. Baloyi, as the court pleases, by court, all the hearsay, Mr. Baloyi, as the court pleases. So, the bulk of the evidence of Zungu refers to hearsay evidence in the sense that no witnesses were called before this court, despite him referring to those people were called before this court to corroborate the evidence of Zungu. The other issue, my lord, that I wish to address is the concerns which were raised by court that at some point accused number 2, Bongani Ntanzi, met Jack Telezi. That is after the court appearance of Mr. Ntanzi, accused number 2, before this court. He refers to this is what Buthelezi says upon that meeting that transpired. He says Bonganti Ntanzi said there was a party and that he said he was in the company of his friends. He said it was Mapisa and them when he referred to his friends. By Mapisa, it was never pursued through the evidence in chief to this witness by the state, my lord, to clarify to the witness which Mapisa was he referring to when he testified with reference to Mapisa that Mr. Ntanzi, accused number 2, had said he was with Mapisa at a certain party with his friends in Vosloorus. Zungu could not explain what occasion on page 47, 48 of Exhibit C, despite claiming that he was with accused number 3 and 4. In his evidence in chief, he testified the person wearing a cap was accused number 2, but when confronted that the person wearing a cap was in fact accused number 4, Mr. Mapisa, he retracted his earlier version and said he could not see accused number 4 in the picture. The common purpose doctrine. Instead versus Mawala unreported case number AR267 of 2016, delivered on the 12th of October 2018, Pillay J at paragraph 19 said the following regarding the doctrine of common purpose. The court held that common purpose is a legal construct to assist the state in prosecution where evidence is insufficient to link offenders to one another and to the crime. It is evident that the principle of common purpose is not just a tool, but an effective mechanism created to serve justice. Without it, the state will have been clueless as to the true identity of the one who committed the act. The common purpose principle makes it easier to not just punish the true actor, but also to his co-conspirators who had the intention to commit such crimes that caused the unlawful results. Those quotation. Instead, versus Mketezi, 1989, volume 1, essay 687, capital letter A in bracket at 705 I to 706 C, the court established that a person to be held liable for a crime committed under the doctrine of common purpose, where there is no evidence of prior agreement, the following criteria must be met. A, presence at the scene. The accused must have been present at the scene of the crime where the violence was being committed. B, awareness of the attack. The accused must have been aware that the criminal attack was taking place. C, intention to make common cause. The accused must have intended to make common cause with the other participants or other co-conspirators committing the assault. D, active association with the attack. The accused must have manifested his sharing of a common purpose by himself, performing some acts of association with the conduct of the others. E, intention to kill the deceased or to contribute to his death. The accused must have had intention to kill the deceased or contribute to his death. In the light of the facts of this case, it is important to note that the common purpose doctrine, as exposed in State versus Mketezi and others, has been pronounced by the Constitutional Court to be constitutional. In State versus Tebas, the most critical requirement of active association is to keep to match a liability. Current jurisprudence premise on a proper application of State versus Mketezi and others makes it clear that 1, there must be a close proximity, in fact, between the conduct considered to be active association and the result. Roman figure 2, such active association must be significant and not limited participation removed from the actual execution of the crime. Zungu's evidence, which I submit, that is version and that of accused number 4, are mutually destructive. Zungu met accused 4 at the hostel. Gwabeni introduced the accused to Zungu, despite Zungu knowing the accused. Zungu later met accused 4 after accused 1, 2, and 3 had entered Gwabeni's room. Accused 5 entered the room, followed by accused number 4. This is according to Zungu. After some time, he was going to his vehicle. He noticed that the vehicle keys were not with him. He went back and asked Gwabeni, where are the vehicle keys? And Gwabeni made a call to a person whom he thought was later to accused number 4. And he made a call to a person whom he referred as Mzala. And he thought that person was accused 5, did not answer the call. Zungu testified that accused 4 arrived and gave him the vehicle keys. According to Zungu, accused 4 showed his greatest fullness and clapped his hands together. Zungu's evidence, it must be noted, my lord, that it does not detail a plan by the accused to execute the assassination of the deceased. It does not place the accused together, or even himself, Zungu, that he overheard such a plan. Zungu's evidence does not reveal any prior agreement amongst the accused, including accused number 4, to kill the deceased. In the absence of a prior agreement to kill the deceased, it therefore becomes important to apply the 5 principles as stated in Gedde's decision. The presence at the scene. The accused must have been present at the scene of the crime where the violence was committed. There is absolutely no evidence, my lord, that accused number 4 was present at the scene of crime where the violence was being perpetrated, either circumstantial or direct, at or near the scene of crime at house number
What about the
135.
confessions?
My lord,
What about the confessions?
I'm still coming to confessions, my
Oh, I
lord.
see.
Yes.
Okay.
B,
That's amusing.
the issue of confessions, my lord.
And,
B-
I'm not thinking what you're thinking.
No, I'm absolutely on different terrains.
Yeah, I can tell you what I'm thinking, not what you think I'm thinking.
All right, thank you.
Section 218
218.
and 217. What do they say?
217 is admissibility of a confession.
217 is about pointing out.
218 is pointing out.
Okay, fine. And then 217 is?
Admissibility of a confession.
Yeah, fine. What does it say?
I'll have to get.
You have the app there so that we all educate ourselves.
In fact, 219 is, I think, for the purposes.
219 is no problem with 219. Yeah, let's read it.
217 is quite lengthy.
Yeah,
It's-
quite, yeah.
Yeah. Well, must I
Yeah,
please
yeah,
on
yeah.
record the whole of it? If it carries my land friend's blessing, Section 217 reads as follows. Admissibility of confession by accused. Subsection 217(1). Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been made freely and voluntarily by such person in his sound and sober senses, and without having been unduly influenced thereto, be admissible in evidence against such person at criminal proceedings relating to such offense, provided, paragraph A, that a confession made to a peace officer other,
Just bring that thing here. It's not what I want us to read. You know what I want you to read?
No, I don't. I'm not thinking what you are thinking.
Yeah. Yeah.
perhaps they could have in mind the confession made to a magistrate, that is prima facie.
Yeah. All right, see. Yeah, just listen, here it is. It's admissibility of facts discovered by means of inadmissible confession. It's section 218, subsection 1.
Yes.
You know it.
Yes.
Evidence may be admitted at criminal proceedings of any fact otherwise in evidence, notwithstanding that the witness who gives evidence of such fact discovered such fact or obtained knowledge of such fact only in consequence of information given by an accused appearing at such proceedings in any confession or statement which by law is not admissible in evidence against such accused at such proceedings, and notwithstanding that the fact was discovered or came to the knowledge of such witness against the wish or will of such accused.
I'm still trying to understand the...
Okay, you remember Ginanda?
Yes.
Ginanda, you kept on asking him, how does he know that accused number 1 is involved? How does he know that accused number 2 is involved, etc., etc.?
Yes.
And Ginanda said, as an investigating officer, after accused number 1 allegedly made a confession to Maboto, I went to fetch the confession the following day, and I read it. You remember?
Yes, I remember that.
The same thing he says about accused number 2, I think. Rapadi, after Rapadi had made the confession,
yes.
written the confession,
Yes.
this guy repeats to say he went to fetch it and read it.
And read it, yes.
The same thing with the magistrate Konje. After he gave the confession to Mrs. Kruger, the senior,
He did the very same
he
process.
did the same thing. So in
Yes.
other words, if you read this, you'll get what is meant by this. So he acquires that knowledge, Kininda, by the fact that he read the confessions. And that evidence, according to this section, is admissible
Against,
to him. But it is not as admissible as against a co-accused.
Yes.
Fine, you have heard me now. What do you think, Mr. Baloy? Is it witchcraft?
Yes, in fact, we quote in the case of Korashi, I think, that deals precisely with that.
Okay, fine. Let's go ahead.
B. Awareness of the attack, the accused must have been aware of the criminal attack was taking place. There is no evidence that accused 4 was aware that the criminal attack was taking place.
Okay.
C. Intention to make common cause. The accused must have intended to make common cause with the other participants or those committing the assault. There is no evidence that accused 4 intended to make common cause with those committing the the assault. D. Active association with the attack. The accused must have manifested his sharing of a common purpose by himself performing some act of association with the conduct of others. There is no evidence that accused 4 manifested his sharing of a common purpose by himself performing some acts of association with the conduct of others.
Okay.
E. Intention to kill the deceased or to contribute to his death. The accused must have had intention to kill the deceased or contribute to his death. There is no evidence that accused 4 had intention to kill the deceased or to contribute to his death. The effect of failure to call available witnesses. The failure of a party to call a witness could, under certain circumstances, justify an adverse inference against that party. It is generally true that where a party fails to lead evidence, available evidence, which can clarify the facts before court, such failure leads to the inference that it is feared that such evidence will expose the facts unfavorable to that party. In this regard, my Lord, Ms. Kelly Khumalo was not called to testify despite being the complainant on the third count of the indictment. An adverse inference will be drawn in circumstances where the state failed to call another witness or witnesses as corroboration, where such witness or witnesses were available to give evidence and was in a position to clarify facts relevant to the case. Evidence of identity. Evidence tendering to prove the person's identity may be direct or circumstantial evidence. Direct evidence is the testimony of the witnesses who says, for example, that the accused is the person whom he saw emerging from the shop at midnight. I submit that there is no witness or witnesses that place accused number 4 at or near the scene of crime. The witnesses who testified viva voce before this court did not implicate accused number 4 as one of the intruders, or that at some point they, that is the intruders, after they had fled, another intruder entered the house. The assertion by Brigadier Kininda that accused number 4 entered the house must be rejected as false beyond reasonable doubt, as they do not find support from the witnesses. Ntokozo Sitwala, who ran out of the house after shots were fired, did not mention this, nor it was raised by the state in examination in chief or when the state was leading this witness. No, the witnesses, Ms. Makete and Mr. Ngache, observe another intruder after the two intruders had fled the scene, coming out of the premises. Despite Brigadier Kininda, my Lord, reading the confessions, it is clear that he did not do any investigations in order to corroborate and find evidence alluende to the commission of the offense. I'm basing this because if it is true that accused number 4 entered the house after the two intruders had left, this was supposed to be investigated, and no investigation emanated from this point. The DNA evidence and fingerprints. Captain Mamshedi Phineas Masetla testified that he was the senior forensic analyst and in the service of the state. He undergone training when he joined the Forensic Science Laboratory in 2002 with reference to opening of parcels containing biological evidential material, the preliminary testing of body fluids thereof, and DNA techniques which he had offered knowledge and skills for forensic biological analysis. He testified that he received continuous training with the Forensic Science Laboratory up until 2006. He had approximately 25 years experience in the biological sciences. He was responsible for analyzing the DNA results in terms of doing the interpretation of the DNA results. He will then do what they call DNA comparison, where he will then have a case like this one, where he will have the DNA from the exhibit, from the scene, and they will also have the DNA results from the reference sample. The reference sample are the samples that are taken from the suspect or accused individuals. Captain Masetla further testified that he compiled what he got from those particular exhibits when conducting his investigations. The lab number allocated for the exhibits from the scene is lab number 217731 of 2014, and lab number for reference sample is lab 126265 of 2016, phosphorus case 636 of 10/2014. The exhibit and reference samples were contained in exhibit X11 of the record. On the 9th of October 2023, the records depict the following at page 75, line 2 to 4. Captain Masetla. At number 22, which details the description of suspect Mthokozeni Mapisa accused for, was excluded from all the samples. Close quotation. A report compiled by Captain Masetla, exhibit X12 in bracket, contains a table where the relevant results from the exhibit, from the scene and reference samples are compared. The first sample is written sample with an indication of 1, that is swap 1, which has the container number 14DCAH8988 and contained in back number PA 400 2150107, which was taken from the door handle of bedroom 1. The next exhibit is a head, which is exhibit B, on the head DNA, and is analyzed with presumable high friction area. In simple terms, it is a sweat. A head was in evidence sealed bag number PA 3000 788535. Captain Masetla received the first reference sample for MZ Mapisa in container number 19DBA F0198 in seal bag number PA 400 4638062. The second sample that he received was from Mthokozeni Mapisa in container number 13DBAD 5906 in seal bag number PA 500 2176171. On the 9th of October 2023 at page 77, line 1 to 6, Captain Masetla said the following. When you go to the next column, it is written gender marker or Emala Godin, which tells us the donor of that particular sample if the donor is a male. If is a male, it will be XY, and if it is a female, it will be XX. In the context of a gender marker, if you have XY, it means that particular mixture, it can be a mixture between a male and a male individual, or simply terms, it can be a mixture of both or more than one male individual. So, and as well as if you still have that XY, it can be a mixture of a male and a female individual. So when you look at XY on a mixture DNA, you must always remember that XY, it does not mean that that mixture is an only male individual mixture. So in a mixture, that XY represents XS, which is a female, or XY, that is from a male individual. He testified that on the 10th of October 2023, page 2, line 13 to 24. My Lord, it is important that before I start checking whether I find that DNA in the swab or in the head, is that for us to say a person is included, you must have to include the person in all DNA regions. So reading a person in one single region does not mean that that person is included in the mixture. Mr. Prosecutor. Now, what is the position if you read that person in more than one region, Captain Masadla? If you read him in more than one region, you must not, for you to conclude that that person is a contributor of that mixture, we have to read him in all the DNA regions. There was a question by Mr. Malloy to the following. Are there any of these regions or loci that are more important than the others? In other words, that are more distinguishing? Captain Masetla asked that the following. We, in terms of distinguishing the character of the loci, we use them in combination to give us a distinguishing factor. So we combine them. It is not necessary to say we attach more importance to one than the other. We match importance to the combination of them all together. From what follows from the evidence of Captain Masetla, my Lord, was the analysis and comparison of swab 1, assembly head B, and various reference samples of known individuals, including Sen Mapisa, accused number 4, and he came to the following conclusion. The donor of the following reference sample were excluded as the donor of the DNA on the swab 1, 14DCA H8988, and the head B presumable high friction area PA 3000 788-535, Phosphorus, case 636 of 10/2014. The importance of this report or results, my Lord, is that circumstantially it further excluded my client, accused number 4, in the commission of the offense. The sole purpose for the head to be sent to this forensic science laboratory was in relation to the friction area, whether one look at whether the head has a sweat, not as what Brigadier Kininda wanted this court to believe. He did his own analysis, which do not find support from the report by Captain Masetla before court. Brigadier Kininda merely says that because the accused, that is accused number 4, is read in one of the regions, then one can conclude that such a report is positive. That does not find support, my Lord, from the evidence of Captain Masetla. And Brigadier Kininda further testified that because the accused is read in one of the regions, it is possible that he had touched the head. That was not the sole purpose for this head, the exhibit, to be forwarded to the forensic science laboratory for examination. The evidence of Sergeant Vusumuzi Mohane. Sergeant Vusumuzi Mohane testified that he is employed by the South African Police Service attached to the National Court Cases Unit. He testified that on the 20th of June 2020 at about 2100 hours in the evening, he was in the company of his colleague, the late Sergeant Mabena, when he arrested Bongani Ntanzi, accused number 2, at Phokeng in Rustenburg. On the 19th of June, Accused 2 appeared before Lieutenant Colonel Rapado for a confession at Moroga Police Station. Accused 2's confession statement was admitted as Exhibit HH of the record. On the 24th of June 2020, the accused appeared before a magistrate, Ms. Cronje, for a second confession statement, Exhibit JJ of the record. On the 6th of October 2020, acting on the information that accused 2 had provided in his confession statement, Brigadier Gininda arrested accused number 4. Brigadier Gininda considered in his evidence in chief that he arrested the accused, that is accused number 4, based on information provided to him, that is Brigadier Gininda, by accused number 2 in his confession statement, that he, Brigadier Gininda, had no evidence against the accused, that is accused 4, before the confessions were obtained. Confessions not admissible against another in terms of Section 219 of the Criminal Procedure Act 51 of 1977. Section 219 of the Act provides that no confession made by any person shall be admissible as evidence against another person. In the Constitutional Court decision of Mhlongo and Nkosi versus the state, which was penned by Judge Theron, or Justice Theron, the crucial issue, my lord, was the admissibility of extrajudicial statements of accused against a co-accused in a criminal trial. The issues arose in 2 applications in which the applicants seek leave to appeal against their conviction and sentences. The court, that is the Constitutional Court, was called upon to determine the constitutionality or constitutional validity of the admissibility of these statements. At paragraph 18 of the judgment, the Constitutional Court justices find the history of the common law prohibition on extracurricular statements against co-accused. At paragraph 18, I quote the following. At common law, the extracurricular statement of an accused was inadmissible against a co-accused. This common law prohibition stemmed from English common law. In 1832, the Court for Crown Cases reserved in R. versus Turner was called upon to pronounce on a conviction for theft. The conviction was based on the evidence tendered in a confession of a co-accused who was an employee of the complainant. The court unanimously held that the confession of an accused was inadmissible against a co-accused, and the conviction was thus wrongfully made. Close quotation. A confession of one accused may not even be used indirectly against the co-accused. What is meant appears from the judgment of State versus Batman, 1960, Volume 3, SA 535, capital letter A in bracket. In which case the 3 accused were convicted of murder. One of them made a confession implicating the other 2. All that connected the confessor to the murder was his confession, and all that lined the other 2 was that the 3 were in each other's company on or at about the crime of the offense. Although the indirect implication of the other 2 in the confession was therefore correctly left out of the court's considerations, neither JA found on appeal that they were nevertheless indirectly and wrongfully connected to the murder thereby. The decision based on Wigmore paragraph 1076, an English decision in R versus Turner, 168 ER 1298, and the appellate division in R versus Nkosi and Zulu, 1950, volume 1, print is all, H 91 capital letter A in bracket. Batman's case was followed by the appellate division in State versus Sorobe, 1968, volume 4, SA 420A at 425G. A confession may not feature at any point in the chain of inference. Even indirect use of the confession for purposes of corroboration is not permitted. In this regard, see State versus Makeba and another 2003, volume 2, SACR 128, SCA at 133, paragraph 14. It follows, therefore, that no reliance should be on accused number 2's confession as corroboration of Zungu's evidence, either directly or indirectly. My emphasis. Section 39, subsection 1B of the Constitution, which requires a court when interpreting our Bill of Rights provisions to consider international law. The term used is must. In terms of section 39(1)(c), also indicate that reference may be had to foreign law but not prescriptive. It provides that only the court may consider it when interpreting those provisions. South African courts actively consider international law when interpreting the rights to a fair trial in terms of section 35 of the Constitution, ensuring that the domestic legal procedures align with international rights standards. The English common law in relation to the admissibility of extraocular statements is useful summarized in the following passage of Lord Elsham of St. Marysbone, Hillsborough, Law of Evidence, 4th edition, 1990, volume 11, 2 in brackets at paragraph 1131. And I quote, confessions by one or two or more accused, where several persons are accused of an offense, and one of them makes a confession or an admission, that confession or admission is evidence only against the party making it. Where the statement is admissible, the information in it may be used to extract from the accused in the form of evidence made on oath all that he has formally said about a co-accused. Statements like acts done by one of several accomplices or conspirators in pursuance of a common design are evidence against the others, but statements which not made in pursuance of a common design are evidence against the makers. Close quotation. The bank records. In terms of section In terms of section 236 of the Act, the state produced proof of entries in accounting records and documentation of bank records, Exhibit EE, subsection 3 in brackets of accused 4. The relevant pages of bank records are pages 21 to 25 and cover the period from the 28th of August 2014 to 30 April 2014. The state indicated that the relevant pages of the bank records were page 24, the entries of 25 October 2014 to 27 October 2014, which depicts the following on page 24. There is nothing in the bank records, my lord, that suggests that accused 4 received any proceeds from the mastermind for the killing of the deceased. In fact, the record supports the accused version, and there is nothing that turned out of them in the state presentation of the bank records that implicates accused number 4. As they show the inflow and outflow of funds, which are immaterial in the present case. My lord, I'm informed that it is $1,300.
Is that so?
Yes. may the court adjourn for lunch.
Until 2 o'clock. This is-
Was his cell phone number. The Section 205 records analyzed by Lieutenant Colonel Gous disclose communication amongst the accused in 2020. Exhibit DD5 in bracket, capital letter B in bracket. Do not disclose any communication between accused number 2 and accused number 4, Mr. Mapisa. There are no Section 205 records for the period of 2014, which were going to be central in this case in relation to the incident of the 26th of October 2014. Colonel Stein testified that this was attributed to the fact that a period of 3 years had lapsed when he did the analysis. The doctrine of joint possession of firearm. Joint possession of a firearm, particularly an illegal one, requires proof that more than one person intended to possess the firearm and that they did so together, not just that one person possessed it on behalf of a group. The mere presence of a group during the robbery where a firearm is used does not automatically equate to joint possession. Evidence must show a common purpose to possess the firearm, with either the actual possessor holding it on behalf of the group, or the group intending for one of them to possess it on their behalf. In State v. Nkosi, 1988, Volume 1, SACR 284W at 286, paragraph H to I, it was that held as follows, that this is justifiable in a factual evidence if the factual evidence exclude all reasonable inference other than A, that the group had the intention to exercise possession through the actual detentor, and B, the actual detentor had intention to hold the gun on behalf of the group. Only if both requirements are fulfilled can there be joint possession involving the group as a whole. In Makubela versus the State, Majeke versus the State, CCT 216 of 2016, also reported in 2017 ZACC 36, 2017 Volume 2 SACR 665 CC, 2017 Volume 12 BCLR 1510 CC, dated the 29th of September 2017 at paragraph 45. Quoting from the State versus Nkosi, 1988 Volume 1 SACR 284, consider W in bracket, at 286H2I, the court said the following, and I quote, "The issue which arise in deciding the group, and hence the appellant possess the guns, must be decided with reference to the answer to the question whether the state has established facts from which it can be properly be inferred by a court that A, the group had intention animus possidendi to exercise possession of the guns through the actual detentor, and B, the actual detentor had the intention to hold the gun on behalf of the group. Only if both requirements are fulfilled can there be joint possession involving the group as a whole and the detentors or common purpose between the members of the group to possess all guns." Close quotation. The Constitutional Court acknowledged that there will be very few factual scenarios which meet the requirements to establish joint possession. This is because of the inherent difficulty in proving that the possessor had the intention of possessing a firearm on behalf of the group. Awareness alone is not sufficient to establish intention of joint possession or possessing a firearm, or the intention of holding a firearm, or the intention of holding a firearm on behalf of the group. Whilst common purpose can be used to prove possession by the group, it is not sufficient on its own to establish joint possession. The state needs to prove beyond reasonable doubt that the accused had intention to possess the firearm either personally or through another member of the group, and that they had the ability to exercise control over it. The evidence of Sergeant Manda Richard Masondo. Sergeant Manda Richard Masondo testified that he is a member in the South African Police Service attached to the Provincial Taxi Violence Unit, which is the sub-unit of the Provincial Organized Crime Unit. He testified further that on the 9th of February 2015, he was on duty during police investigations in the company of his colleague, Sergeant Lamine. While on duty, he received an information about a suspect he was looking for. As a result of their investigation, a 9mm Czech Republic loaded with 15 rounds, live rounds of ammunition were found, and one ammunition was on the chamber, and a blue box with 12 live rounds of ammunition with different caliber in a room allegedly occupied by accused number 3. They proceeded to Cleveland Police Station to open a case of possession of unlicensed firearm under Cleveland Case 96 of 2, 2015, SAP 13, 86 of 2015. The firearm was sealed in evidence bag number FSE 385083. The evidence of Lieutenant Colonel Christian Mangena. Lieutenant Colonel Christian Mangena testified that he is stationed at the ballistic section of the Forensic Science Laboratory and employed as a forensic analyst. On Monday, July 2020, during the performance of his official duties, he booked out and exhibit firearm and ammunition at Cleveland Police Station under Cleveland Case 96 of 2, 2015, SAP 13, 86 of 2015. The exhibits were received in an open evidence bag number PA 4000810885 and were booked out for further investigation purposes as per Phosphorus Case 636 of 10, 2014. On the 27th of July 2020, exhibits, firearm and ammunition were booked back at Cleveland Police Station, sealed in evidence bag number PA 400-440-4332. On the same day, the exhibits were booked out at Cleveland SAP 13 store by Brigadier Geninda. Lieutenant Colonel Mangena testified that he compiled the report in terms of Section 212, subsection 4, small letter a in bracket, and 8a, small letter a in bracket of the Criminal Procedure Act 51 of 1977 as amended, Exhibit X 13 in bracket C in bracket. He recorded his findings at paragraph 9.1 of his report. The cross-examination of Tumelo Madlala. Mr. Ramsepele asked the following question, and I quote, and then also could you tell if the farm had a wheel on the side, something that looked like a wheel or a rotating object on the side? Madlala, I looked it, like I have already said, that I did not take a lot of time to observe that particular firearm, but it looked to me as though it was a firearm that had a wheel on it. You find this on the transcribed record dated the 8th of August 2023, page 6, lines 16 to 22. Advocate Mnisi posed the following questions to Mr. Madlala. Thank you. But now this one, a distinctive feature of it, it looked like there is a wheel. Mr. Madlala responded in the following respect. Yes, I have already said that, yes. And when I looked at it, I saw it from the front portion of it. Close quotation. They were said, Watermeyer J.A. in R. vs. Blom, 1939 AD 188 at 202 to 203, two cardinal rules of logic that could not be ignored when it comes to reasoning by inference. 1. The inference sought to be drawn must be consistent with all the proof facts. If it is not, then the inference cannot be drawn. The proof facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is the correct one. Thus, from the evidence of Tumelo Madlala during cross-examination, the proof facts of the ballistic report cannot be the only reasonable inference to be drawn, as they do not exclude every reasonable inference to be drawn. Then there is doubt whether the inference sought to be drawn is the correct one. The test for joint possession of an illegal firearm is well established. There is no independent evidence that accused 4 participated in the murder and the subsequent robbery, or that he was part of the conspiracy to kill the deceased. The state did not prove beyond reasonable doubt the inference that he had intention to exercise possession through the actual danger, and that the actual danger had the intention to hold the firearm on behalf of the group, except what is contained in the confession statement of accused number 2. In terms of the 5 principles I've alluded to, enunciated in the State versus Mkete's decision, that is the presence at the scene, awareness of the attack, intention to make common cause, active association with the attack, intention to kill the deceased, or to contribute to his death, I find none. It follows, therefore, that the state has failed to establish a prima facie case in respect of counts 4 and 5 of the indictments, and to this end, he must be acquitted. Conclusion. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold. In short, my Lord, what I'm submitting in my heads of arguments is the following: that there is no evidence tendered by the state upon which this honorable court may convict accused number 4. The onus is not on the accused person to prove his innocence. It has always been the duty of the state to prove the case beyond reasonable doubt as far as 1961. It is not the duty of accused number 4 to go to the witness box and supplement the state case in any way, or incriminate, or by so doing, incriminate himself. For the aforegoing, I submit that the accused that is accused number 4 be acquitted and discharged in terms of the provisions of Section 174 of Act 51 of 1977, dated at Pretoria on the 15th of August, 2015. Thank you. 2025. Thank you, my God. Thank you.
Okay, thanks. Yes, sir.
As you could, please, my Lord, we ready to start with our submissions. However, the fact of the matter is that we will not finish this afternoon.
Oh, so?
The question is whether should we start and then continue tomorrow, or just continue tomorrow? Or,
What's the view of the other
in other words,
councils?
commence tomorrow.
What's the view of the other councils?
My view, my Lord, is I think it will be, the interest of justice will be best served if we start the submission by our colleague on a clear mind, my Lord, because we also need to concentrate. We have overly concentrated today. I'm afraid if we were to start another chapter, a new chapter in this application, we might miss a factor or two,
All right.
as we are noting down, my Lord. Thank you.
Yes, Mr. Ramsepidi?
This is my Lord, I do concur with Advocate Munesi that we should start in the morning, my Lord.
Thank you, my Lord. I have no objection to the request to start tomorrow
What is the
morning.
request? Because
To
we are
roll over.
finished.
To roll over.
No, I'm just joking.
Yes.
Yeah, and Ms. Nishodo?
No objection, my Lord. We can roll over until tomorrow.
Yeah, in the meantime, this court in terms of section 186, I haven't yet made a final decision, but I think in the interest of justice, it would be fair to record the evidence of Mr. Makela. Is it Mr. Makela, the gentleman who was at the garage? Allegedly at the garage.
No, but he's passed on.
Yeah, I know that. That's
Yes.
why I'm saying 186.
Yes.
Which section do we normally use?
Is
I
it-
know it's evidence rule, section 3,
Yes.
1988.
Yes, that's,
Yeah, in the interest of justice, when you want to call a witness like this, because as Mr. Mwamalo was arguing, making submissions, I'm thinking that this witness, allegedly, he saw something. According to Ginanda.
yes, Mr. Makaleni.
Makalenia,
Yes,
and
yes.
Ginanda is the one who took
His statement.
the statement from him. Are you aware of that case?
Yes.
State versus KLB. It's in Britain, 1983. But it was used in South Africa by two judges, Sishi and Madondo. Are you anybody aware of that case? I can bring it tomorrow.
Yeah.
You've never heard of that case, sir?
Yeah.
Mr.
Well,
Ramsepit.
Never had man.
Yeah. So what it did is, there's a case in Britain which some of our courts in South Africa have used. This gentleman was charged with rape in Britain. And he was subsequently, after being charged, he died. He died. But the detective who took the statement from him was still alive. And the full court in England ruled that because this evidence may be useful in trying to sort out this very case before the full court there, you can listen to the evidence through the investigating officer. The only proviso was that the investigating officer should have sworn in this witness and told him what is the effect and the difference of adducing evidence on a statement under oath, and what are the consequences if you are lying. You remember that?
yes, yes, yes. Yeah.
That's it. And it was allowed, that case, on that basis, that it would be in the interest of justice to listen to this evidence through the investigating officer, because he is the one who contemporaneously took the statement of the deceased. Like in this case, it's Geninda who says he took the statement.
No, I think it was taken by someone else.
Is that so? It's not Geninda.
No, it's
took-
not Geninda.
Just check for me.
Yes.
Okay.
No, it's definitely
Everybody
someone
can
else.
check for us, so that we must see whether it's a waste of time or not. So you say it was taken by somebody else?
Yes.
Who? Mohani?
We'll just get
Mamfundisi? Who?
hold of the states.
Who?
We just want to verify now, but
How
our
many
recollection.
investigating officers were there?
Yeah. Yes, the court will recall that there were different teams working on this
Oh, by
matter.
the way, yeah, okay, fine.
So it was taken by the
Possible-
team that
Oh,
was
all right,
involved
okay.
right at the beginning.
Okay, fine. Okay, let's meet tomorrow then. We'll check that.